through the cabinet secretary responsible for environment, did establish a task force via Kenya Gazette number 10944 of 10th November 2017. And that was just immediately after the initial judgment of this court. And that judgment was, that task force was tasked with the mandate of advising the state on how to implement the judgment of this court.
Yeah, that's what I'm checking.
And as regards the applicant community, that's the OGX. In terms of the orders of this court, which required that there be consultations with the community that is before you, that task force did engage the community through various mechanisms. And in our report, we have demonstrated that there was the use of radio, as well as social media, Facebook, Twitter handles, and the radio stations that were used to ensure consultations majorly were the ones with extensive reach to the community and also within the local language of the community. And these were KBC radio and Kitwek, which have a high audience and listenership within the Mau Forest. That spirit of consultations, my lords and honorable judges, is also in the context of the Kenyan state. In our constitution, at Article 10, public participation is one of the values and has been given prominence. And that aligns very well with the judgment of this court. So that has been done. Additionally, the task force did visit the areas that the community is at. And we have set out those areas. If you look at our report, page 5, we have set out various areas where the task force visited and met members of the community. And we have uploaded photographs for the view of this court. Additionally, there were public hearings that were held by the task force. And all these, including submissions by members of the OGX community on how to implement this judgment of this court. One thing that came out of that engagement was a realization that there had been various attempts at addressing the land question for the OGX. And what emerged, and it is set out in our report, is some members of the community had been allocated land, but had later sold that land to other persons, including persons of other communities. And what the task force report said about that is, for the full implementation of this, of the judgment of this court, there will be need for purposes of fairness and equity, and to avoid a situation of unjust enrichment. For those who have benefited from previous allocations and they sold, to be removed from any further benefits of getting land as directed by the court. Honorable judges, we are submitting that there has been extensive consultations, extensive input received from the community, and that was given to the task force that I have alluded to. Additionally, honorable judges, an interministerial committee to address mechanisms, identify steps of implementation of the judgment of this court was also set up by the Principal Secretary, Minister of Environment, Forestry, and Climate Change. The committee has not finalized its report. Once it is finalized, adopted by all the members, it will be submitted to this court. And that is in the context of what I've said, that this is a continuous process. It's a progressive realization of the fruit of this judgment. But if I may allude to just what has happened with that interministerial committee. They are still engaging members of the community, and once that report will be available, we'll be able to speak to it. I've alluded to two steps that have already been taken in terms of identifying the roadmap and implementation of the judgment. Additionally, my judges, on the 25th of February of April 2022, the Cabinet Secretary in the Ministry of Environment and Forestry wrote to the National Land Commission, which is a constitutional commission in the Republic of Kenya, charged with matters land, matters public land, matters historical injustices, and all that. And that commission was requested to identify the objects and open a register for the objects. In our report, honorable judges, we've set out the mandate of that commission and what the law expects them, or the Constitution of Kenya and the laws of Kenya expect them to do. But in the context of this judgment, of this hearing, we are submitting that the National Land Commission, which is an arm of the Republic of Kenya, did identify or was tasked to identify and open a register of the members of the Ogiek community and also identify land for settlement of the Ogiek. In doing so, the commission liaised with counties within which the Ogieks are, and also public officials within those communities, that is the chiefs, being administrative officers within the hierarchy of government, who are charged with local leadership in those areas. We have set out how that commission held hearings, several hearings in terms of the judgment of this court on consultation and public participation. And several hearings were held at Nakuru. That was on 7th of August, 2023. Various distinct groups of the Ogieks that came out, such that, and my colleague will be speaking on the challenges, he'll be alluding to that the applicant is not as distinct groups within it. And these are set out at page 7 of our report. That National Land Commission, my lords, my judges, undertook a verification and validation exercise at the Mau Forest Complex from 8th to 11th of August 2023. And what they were validating is the report that the commission had come up with in terms of identifying the objects and in terms of identifying how to implement this judgment of this court. The commission did find that, of course, and as I have alluded to, that there are splinter groups, several splinter groups within the community, so that we are not dealing with a unique community, but a community that has different representatives, different views, different visions, and that, of course, will present a challenge. But as I have said, this is a progressive affair, and we'll see how to go about it. My judges, the commission did identify a list of the objects, and that is one of the requirements of this court. And just speaking further to that, because there was an order by this court for the Republic of Kenya to give full recognition of the objects, we are submitting that the Republic of Kenya has recognized the Ogiek language, it has recognized the Ogiek culture and religious practices. Honorable judges, in our report, we've alluded to the Kenya National Population Census of 2019, in which the Ogieks were enumerated as a people. And while I have seen several reports from the applicants that there are 20,000, in that report or in that census, it is our submission that they were enumerated and recorded at 52,596 individuals. So there is efforts or compliance in recognition of the Ogiek as a community with its distinct cultural practices. Honorable judges, we are submitting that the Kenyan Constitution, the Kenyan courts, and the judgments are there for the court to see, have identified the Ogieks as an indigenous community. So there's recognition of the applicants to that extent. As I wind up, my lords, my judges, it is our submission that the process of compliance with the court judgment is ongoing. We have demonstrated steps, including those task forces, the interministerial committees, which are working and in consultation with the Ogiek community on compliance with the judgment of this court. And this court did order that we consult the Ogieks. That consultation is ongoing. It is a process. And my colleagues will be speaking further. And of course, we have seen from the applicants, the Hamike, that this engagement will continue. So we'll be submitting that. We continue with this engagement and we continue reporting on the status of compliance. I will invite my colleague to just speak on the challenges, which I have alluded to briefly, but he will speak more to it. Thank you.
Your Lordship, my lady, my name is Maro Christopher once again. And with your permission, permit me to speak briefly on the question of challenges that the Republic of Kenya is experiencing in an attempt to implement the judgment of this court. Your Lordships, the first challenge that the Republic of Kenya is experiencing is on the question of institutional and legal barriers. Part of it has been occasioned by the applicants who are before this court. Your Lordships, in 2023, the Ogek community, suing through the chairman of the community, instituted a claim in our municipal court, being then the environment ELC number 1 of 2023. In that matter, the Honorable Attorney General, the Cabinet Secretary responsible for Ministry of Environment, Forestry and Climate, Kenya Forest Service, Kenya Wildlife Service, the Inspector General of Police, and the Rift Valley Regional Commissioner were parties to the proceedings. The parties I have mentioned are key in implementing the judgment of this court, in particular, the ruling on reparations. In this particular matter, the applicants sought to enforce the judgment of this very court before our municipal court. So that had an impact in slowing down the process of implementing the judgment of this court, because all these parties had to respond to the claim before court. On the 30th of May, 2024, a judgment was delivered where the court dismissed that particular claim and ruled in favor of the respondent, being the Republic of Kenya. So that had an impact in realizing full implementation of the judgment of this court. In order to fully realize the implementation of this judgment, a number of institutions have to work together. Among them is the Ministry of Environment, the National Land Commission, Kenya Forest Service, among others. We submit that the process is ongoing. My learned senior submitted that the National Land Commission did undertake the process of identifying the real Ogek in order to fully realize the implementation and allocate them the land that they are seeking before this court. We have the historical complexity and the sensitivity of the land issue in Kenya. Mau Forest is a very sensitive land that Kenya seeks to protect for the benefit not only for Kenya, but for Africa at large. Kenya is a signatory to many international treaties and has a duty to obey those treaties. Among the treaties that Kenya is a signatory to, with your permission, if I may read them, Kenya has ratified the United Nations Framework Convention on Climate Change. Kenya has equally ratified the Paris Agreement, the Kyoto Protocol, the Montreal Protocol, and the Vienna Convention on the Protection of the Ozone Layer. The Mau Forest, which is a subject of determination, which I believe this court made a finding on, is not only of benefit to the Republic of Kenya, but to many countries. It is a source of many rivers that seeks to protect and benefit Africa at large. So those are challenges that the Republic of Kenya is facing while trying to implement the judgment of this particular court. Yes, we concede. We are doing our very best to implement the judgment of this court. But the same has a number of problems, and we are informing this particular bench that as we do so, we'll be asking for a considerable amount of time so that we can fully implement this judgment. We also have a problem of financial constraint that the country is facing. This has a bearing in realizing full implementation. Your Lordships, if I may, in Africa, Kenya has equally ratified the African Convention on the Conservation of the Nature and Natural Forests, which, if I may, states that when exercising the right to exploit their own resources through the environmental and development policies, member states must ensure that activities within their jurisdiction or control do not harm the environment of others. The question that was before this court and that was determined in the year 2017 and the question of reparation determined in 2022 is on the Mau Forest, which is a critical water catchment area for Kenya and Africa at large. We concede that the judgment of this court rendered in the year 2022 on reparation. What?
My Lord President, there appears to be a technical problem.
Nous vous entendons très bien ici. Hein? Il y a l'interprétation que
Can
nous
hear
avons
you
ici.
very well.
À notre niveau.
You can receive the interpretation up here. So
Paradji, c'est bon. Nous vous entendons bien ici. Il n'y a pas de problème. On peut
we
continuer à
can
parler.
hear you very well. So continue, proceed with the
My
submissions.
Lord the President, I wish to have a confirmation from the court that I am audible. Okay. Thank you. Sorry for the intervention.
If I may, as a country, Kenya is also experiencing political challenges in an attempt to implement the judgment of this court. When we were before this court last year, one of our submissions that we made while seeking an adjournment was on the issue of government appointments to these critical departments and ministries that we have had a number of reshuffled in the cabinet. Some of these cabinets and ministries are key in implementing this particular judgment. So whenever we experience change in a particular department and ministry, that has a very big bearing in implementing this particular judgment. Several national authorities have varying mandates, and this has an impact in realizing full implementation. Your Lordships, finally, the National Land Commission is engaging in an active consideration This is the report that was submitted by the National Land Commission on the identification of the Ogek community. Is under active consideration by the National Executive, as this has a significant political, economic, and national implication. So this particular report on the identification of the Ogek community is on, I believe, before the executive, and this will also take a bit of time before the report now is rolled out for implementation. We will be requesting this court to give us relatively considerable amount of time, and this will be submitted on by my colleague, Ms. Mutindi, in response to the submissions made by the AMICA, drawing a comparative analysis on how other regional courts such as this have given a wider latitude when it comes to compliance of a sensitive ruling and judgment such as this. We submit. Thank you.
Honorable judges of the court, thank you for this moment. I want to invite this court to a comparative research study done by the University of Rotterdam on the compliance of rulings on rulings issued by the Inter-American Court on Human Rights, a court established 46 years ago with the same jurisdiction as this honorable court, which was founded to promote human rights, social and economic development. Honorable court of this court, the Inter-American Court on Human Rights, since its establishment 46 years ago, that is in 1979, has been able to issue 550 judgments. These decisions have been on various issues on human rights violations, including the rights of indigenous communities. Now, between the years of 1989 and 2018, and I'm quoting these years because I said the research study was done in 2019, the Inter-American Court on Human and People's Rights ruled in 238 cases. 1,782 reparations were made, and by 2019, only about a third of all the reparations had met full compliance. The picture I'm trying to draw here is that compliance is a continuous process and it takes time. Of those who had complied, only 5 member states out of the 558 pronouncements that were made by the court to various member states. And the member states are about 20 plus. Only 5 states, honorable judges, have complied with every obligation towards their victims. Only 5. And this has mainly been on monetary and symbolic measures. Still on this study, it has shown that on average, it takes 8 years from a time a ruling is done by the court to identify the first form of compliance. On the part of Kenya, I think what my colleagues have submitted on is an indication of the first step of compliance. Partial compliance, my lords, my ladies and my lord. The research also says it takes about 11 years until the court identifies full compliance. Various challenges are alluded to this. I will not go into details because they are well articulated in that research paper, and my colleague has mentioned some of them, and these include political, financial resources rather, and the complexity of the issues involved as they cut across various other communities that are also affected by the judgments of the court. Honorable judges of the court, I will not dwell much in the research paper, but I want to say this in conclusion. Drawing to the case of the respondent state, various measures are being undertaken. We are making fast steps, if not baby steps. We are engaging the community of Ogiek, and other communities were also affected by this judgment. It is evident, honorable judges of the court, drawing from the Inter-American Court on Human and People's Rights, the Inter-American Court on Human Rights rather, and also this court. Rights are founded on a shared commitment to justice, dignity, accountability and compliance with court rulings. But challenges abound on the states, not out of sheer disobedience on compliance, but due to the complex interplay between the legal, institutional, and political factors of the member states. We are not saying that these challenges cannot be met, but they must be appreciated that they exist. And the respondent state has to maneuver them in order to realize this judgment, and for the Ogiek community to enjoy the benefits of this judgment. Honorable judges of this court, given the research paper that we have submitted before you, it is clear that compliance with international court rulings and decisions remains somewhat difficult in order to achieve full compliance. And despite the challenges that have been articulated by my colleagues, honorable judges, the legitimacy of any human rights system must and will be achieved. And the respondent state is taking steps to ensuring that we will achieve what this court has ordered. The respondent state continues to advocate, to embrace broader efforts, as it has been demonstrated by my senior, Mr. Mutinda, that we are also engaging the Ogiek community to be part of the implementation process, despite the difficulties. And my ladies and my lords, in closing, I wish to state the Inter-American Court on Human Rights and the African Court on Human and People's Rights They are founded on shared commitment to justice, protection of human rights, dignity. And it is a responsibility not just of the member states, but also of this court to make sure that these attributes are met. We therefore ask, let the respondent state do what this honorable court has ordered. And in the process, we politely ask, let us also consider the fact that even other courts, similar courts, international courts, who dispense the same mandate as this one, protection of human rights, realization of human rights, have continued to issue judgments and decisions that have taken time to be complied with. Therefore, let the Honorable Court give Kenya time to comply with the order of this court. I so submit. Thank you, Honorable Judges, and have a good day.
My Lord, the Vice President, the President and Vice President, judges of the court, allow me as we come to the conclusion, first to request respectfully the court to consider adding the respondent 10 minutes. And if I have your permission, then I will address the court in conclusion.
La Cour vous accorde 10 minutes pour conclure, s'il vous plaît.
Grants you 10 minutes to conclude, please.
Thank you, Mr. President. The Honorable Court. I believe the court today has been asked to consider the fundamental question whether or not the respondent state has complied with the judgment of this court. I think a corollary question that is being asked of this court is whether the state has reported to the court, and reporting in itself is an important action, has reported to the court on its action or inaction furtherance to the judgment of the court. My Lord, as we appear before you, I think although we are first styled as respondents, it is good to clarify that the respondent state views itself and the original applicants, that's the Ogiek community, as a commune in pursuit of common interests. So that the respondent's response before the court is not being pitted against one of its community. When the court will retire to consider the report of the respondent, several things will emerge as already have been alluded to before in the submissions. One is that the respondent state has taken action. In fact, immediately after the issuance of the judgment of this court in the year 2017, to commence the process in the domestic sphere First, of understanding the implications of the judgment. Secondly, of seeking a pathway, in fact, a pathway of least resistance to bring about compliance with the terms of that judgment. And I think we have produced the various interventions that the state has put in place to secure the eventual full enjoyment by the Ogiek people of the terms and the benefits of this judgment, part of which has been provided for in the interagency team, the interministerial task force, the National Land Commission. In fact, when the court retires and looks at both the affidavits filed by the respondent state and those filed by the applicant, you will see evidence of multiple agencies of state, each of them seeking ways and means to address the compliance with the judgment of this court. On the question of recognition, which again is paramount, the dignity of a people is first realized by recognizing them. As already has been pointed out, in the census on 2019, which was not the case before, this cherished community amongst the peoples of Kenya was enumerated singularly as a community, and a number fixed to the population as taken during that census. That in itself is an act on the pathway of compliance. And I believe when the court again relooks at the terms of its own judgment, one of the things that the state was being called upon to do is to recognize. And there are several ways in which recognition comes, meaningful recognition. One, by including this community in the statistics of the Republic of Kenya. Now, going to that, the state has looked beyond the benefits of the judgment and has sought to draw this community at the seat of development and economic consideration in the census. With the incoming of the current regime, again, this court will also find that there is now in place a minorities and marginalized persons unit in no other place than the presidency, the executive office of the presidency, which is addressing the broader issues of the marginalized and minorities in the Republic, so that the benefits of this judgment are not only enjoyed in isolation, but will be comprehensively enjoyed when the rights of minorities and the marginalized in the Republic of Kenya are comprehensively addressed. They are included in every other aspect of the social life, political life of the Republic of Kenya. Not to cast any wrong motive on the part of the original applicant, that's the Ogiek people, believing in the rule of law, as my colleague has already adverted to before, and their right to approach the courts. The place of democracy, constitutionalism, and rule of law allowed for the Ogiek in the domestic sphere to approach the courts of the Republic of Kenya. And as they did so, the Republic, respecting constitutionalism, participated in those proceedings, and the record will bear that out. Now, in the course of the proceedings before the domestic courts, obviously there will be pronouncements that may decelerate the rate at which the Republic seeks to enforce or comply with the judgment of the court. But note, I say decelerate, I do not say dissuade. So that, as my colleague has alluded to here, with the experience of the Inter-American Court, the privilege of the state is to balance, to allow the citizens to enjoy their rights, both international, recognized, and nationally enshrined in the Constitution. And whilst there is an intervention that decelerates the rate of compliance, we again are sent back to the drawing board to reimagine which path would be best to bring about full compliance with this court's judgment. My Lord, the President and the court, you will also note that from those proceedings, at no occasion has the respondent state approached the domestic courts in any way to challenge the decision of this court. At no point. In fact, in none of those proceedings has the respondent state moved the court on an action against the community. Lastly, my colleagues also did allude to the outcomes of the work of these teams, the interagency, the task force. And as the task force has engaged with the question of implementation and the interagency team, what also emerges, and which should come to the bear of the court, is that we're also not dealing with one homogeneous group. In the course of implementation, there will be the emergence of even differences within the community of how this judgment should be implemented, and especially on the quintessential question of the land. That, again, my lords, I submit, is a privilege of the various constitutional commissions and agencies that have been given the mandate to identify, to clearly delineate, register, and assign different forms of land to different usage. You will see, for instance, the conflict that emerges when you want to manage the forestry. The Mau itself is not a place which is habited by only one community. There are multiple communities. This happens to be one community. And in the course of implementation, we are also guarding against advantage being taken off this process to allow for those who should not benefit from the benefits of this judgment to enter the Mau complex. In the process of doing so, of course, there will be many missteps. I'm not saying there have been any, but each and every one of these attempts have actually been to preserve this very place where the original applicant will be asking, please allow me to have a home. What are we saying, my Lord President and the court? The report of the state demonstrates a willingness. The report of the state also demonstrates a pursuit of ensuring that what this court pronounced is given not just effect, but full effect. And that will mean balancing many interests. It will mean operating within the rule of law. As you retire to consider the requirements of the Community Land Act, one of the things that emerges in the course of implementation is that before we can address the question of community land, we also have to deal with the views consulting with the community. Some who are of the view that they should not go through the path of community land, but individual land. That the state has to address. Community land juxtaposed upon public land, forest land. Those are questions which this generation must handle delicately so that not only the future of the community, but the future of the entire republic and the extent to which the Mau influences the region and beyond must be put into account. So what we are asking this court to find is that in the first step, we have reported to the court. That's part compliance. In the second step, as you look at the report, we have enumerated the steps we have taken to bring about compliance and allow for the state to engage with its communities, including this one, to conclude this task. Thank you, my Lord the President.
Merci à vous. À présent, nous donnons la parole aux honorables
At this juncture, we are going to
juges.
give the floor to the honorable judges if they have any question for the respondent
Très
state.
bien. Honorable juge Ben Salah, vous avez la parole.
The Honorable Judge Ben Salah, you have the floor.
Allez-y, s'il vous plaît.
Go ahead, please.
Merci, Monsieur le Président.
Thank you,
Et
Mr.
j'aimerais poser une
President.
question
I'd like
à
to
l'État défendeur.
ask a question to the
Dans sa
respondent
plaidoirie,
in
il parle un peu
its
de
submissions. It
ces
talks
difficultés
about
ont par rapport
problems
avec
of
la nature
implementation
humaine,
or
c'est-à-dire
enforcement,
le dossier,
which has to
financier.
do with the nature of
Et à un
the
certain
case
moment,
itself,
vous
which
avez
is land,
parlé
and then
du
financial
délai,
problem.
vous avez
And then
demandé
you
un
also
délai.
spoke about
Est-ce que ce délai
a deadline.
renouvelé pour
You requested for
un
one.
rapport final d'exécution
Is this to ensure the final
la
report
durée
of
du rapport,
enforcement, or like one of your countrymen said, you cited the example of what the Inter-American Court said, in which some states were given 8 to 10 years to enforce judgment. What difficulties exactly are you talking about? Is it financial, or is it just about difficulty with time, which you need, or does it have to do with the land problem, for which you are trying to provide a solution, or is it just time for you to bring a final report on the enforcement of this? Thank you, Honorable Judge.
Honorable juge Anoukam, vous avez la parole, s'il vous plaît.
Honorable Judge Anoukam, you have the floor, please.
Merci, Monsieur le Président. I wish to thank the respondent state for their submission this morning. I have 2 questions in which I seek clarification. The first has to do with the case you mentioned at the domestic level, the municipal case. Who is the plaintiff in that case? Who initiated that action? And what is the effect of that case? Whether it's going on or not, you need to tell us the status. And what is the effect on the implementation of our own decision? Are you with me, Counsel? So the bench will want to know the relevance of that case and its effect. Who the plaintiff is it ongoing? Is it concluded? Those are some questions we want you to address. And the second has to do with the implementation process, which you seem to say is ongoing. And the question is, when do you intend, as the respondent state, to give full effect to the judgment, the 2 judgments of this court? I thank you.
Honorable Judge Mila, vous avez la parole, s'il vous plaît.
Mila, you have the floor, please.
Thank you, Honorable President. I also have 2 clarifications that I'm seeking from the respondent state. The first one is you have mentioned that the Mau forest is a very sensitive forest, not only to Kenya, but to the whole of Africa. Could you please clarify what you mean by that? Secondly, you also mentioned that the respondent state has not appealed against the judgment of this court in your domestic courts. Could you also clarify what you mean by that? Thank you, Mr. President.
Merci, honorable juge. Honorable juge Dumisa, s'il vous plaît.
Judge, Honorable Judge Domisa, please, you have the floor.
President.
Mine is also a question of really clarification. And a correction if I did not understand your arguments to be. Generally, I understand your argument to be that generally everything has been done by the respondent state that could possibly be done to comply with the court's previous orders and injunctions. And that process is ongoing. Now, in the process, there was, if I heard correctly, there was a reference to the Inter-American Court. I would like to know in what way this was sought to assist the argument. Thank you, Mr. President.
Merci, honorable juge de Missa. À présent, honorable juge Menges, qui sera suivi
Judge de Missa, Honorable Judge Menge will be next.
Merci, Monsieur le Président. Monsieur le Président,
Mr. President, I would like for the respondent state to shed some light on a precise case which was recurrent in their submissions.
Il a été mentionné que l'une des difficultés
It was stated that one of the difficulties which the respondent said met in giving effect to the decision of the court is the multitude of groups existing on their territory. That is, there isn't only one community living in the forest at the heart of this issue, and that the state is determined to identify the real object. Does that mean there are false objects? And if there are several communities, what measures are being taken with respect to these communities to avoid a situation where these other communities will also approach the court? These are the questions that I wish to ask the respondent state. Thank you.
Je vous remercie, honorable juge Duncan, s'il vous plaît, vous avez la
Thank you,
parole.
Honorable Judge. Honorable, you have the floor.
Thank you, Mr. President. Two short questions, because some of them have already been asked. One, a number of orders were made in the judgment, and we can see that some action has been taken. With regard to the order for pecuniary reparations, Council Mara made a statement that the respondent state is facing some financial challenges and left it at that. So nothing has been done with regard to that particular order. So, do you hear me?
Yeah.
Okay. So nothing has been done with regard to that particular order. I would have thought that, well, we understand, even if the respondent state was facing some challenges, probably if the sums that were ordered to be paid would be paid in bits, other than leaving it just outstanding as was earlier ordered. Second question. I had Council Maro and Council Mutindi use the phrase considerable amount of time, that we would need a considerable amount of time to complete this particular aspect. Whereas
my sister Judge Stella has asked for the time when full compliance will be realized. I want to ask for those particular items or orders that you kept saying, even on this one, we need a considerable amount of time. Could it be at least indicated how much time will that be? Thank you.
Merci, honorable juge Duncan.
Judge Duncan.
Honorable juge Adjei, vous avez la parole.
Honorable Judge Adjei, the floor is yours.
Thank you, Mr. President. I would like to ask this short question. From your reports, you are alleging that there are multiplicity of suits in respect of the same subject matter, in which judgments have been given in respect of some of them. I would like to know, when was the first time the action at the national level was instituted? And was it after the judgment of this court has been rendered before those actions were instituted? That is what I want to know. Thank you, Mr. President.
Merci, honorable juge.
Thank you, Honorable
Adjei.
Judge Adjei.
Honorable juge Anoukam, vous avez la
Honorable
parole, s'il vous
Judge
plaît.
Anoukam, the floor is yours.
Merci, Monsieur le Président. I would like the lead counsel to please look at the written submission. And I would wish to seek a clarification on the last statement contained in your submission, which looks a bit ambiguous to me. Perhaps you can shed more light. What is it? Have you seen it? Even me, I'm looking for it now. I can read it if you have you seen it? Okay. In conclusion, I'm reading now from your report dated the 8th day of May, 2025. Signed by the Solicitor General, Honorable Shadrach J. Moses, CRS. You have it? You have it? Okay. So it reads in the last paragraph, in conclusion, it is the respondent state's position that compliance with the decision of the court will realistically take more time than envisaged. And my concern is this, and may not be to the extent provided. We'll appreciate if you could throw more light on that, particularly the last portion of the statement, may not be to the extent provided. In what context, and maybe more light. Thank you. Thank you, Madam. Thank you, Mr. President.
Merci, honorable collègue.
Colleague,
Très bien.
very well.
Pas d'autres demandes de prise de parole.
I don't see any further hands raised for questions.
À présent, nous invitons
At this juncture, I'd like to invite
la partie requérante
the applicant
à soumettre ses observations orales, s'il vous plaît.
to present its oral
Merci.
submissions. Thank you.
Thank you very much, Honorable President. I would like to start by, first of all, acknowledging with appreciation the submission by the respondent state, in which the counsel for the respondent state affirmed full commitment of the Republic of Kenya to fully implement the merit and reparation judgments of this court. We would like also to indicate that the respondent, both in the written submission on implementation, that is the report on implementation, as well as in the oral presentation, admitted that there are parts of the orders of this court that are not implemented. Building on the various written submissions availed to and in possession of this honorable court, which establish lack of implementation of the orders of the court, judgment on reparations, the orders of the court, the expiry of timeline that the court given for implementation of certain orders, actions of the respondent state that fundamentally go against the core of the court judgments, and actions that make implementation increasingly untenable. The legal team who will be addressing the court from the bar will present compelling submission as to pose why and how the report of the respondent state on implementation and the affidavits it filed, as well as other accompanying submissions, do not contain specific, concrete evidence of meaningful implementation of any specific orders of the court. And this leads to the perpetuation of the violations that this honorable court established in the merit judgment. And the additional actions that were implemented constituting further violations, thereby condemning the OGEC to destitution, displacement, and mithering. And as the legal team will show, even in respect to the measures outlined by the respondent state in terms of initiating processes. I mean, these are still processes, not really actual implementation, right? It is our submission that the court needs to ask the question whether, in respect of those different processes from the task force to the National Land Commission to the Interministerial Committee, whether or not in initiating these processes as requested by this court, the OGEC have actually been consulted in the initiation of these processes themselves, and therefore constituting these processes. And whether or not with respect to, for example, the task force, the OGEC have been provided with the report of this task force that has been presented. And we acknowledge with appreciation the submission by the respondent state about one specific aspect, which is the recognition, which this court requested, of the OGEC as indigenous peoples. We would like to request this court, given that the order that it has given in the reparations judgment, which came after the census that the respondent state made reference to, whether that census actually is adequate enough to give full recognition to the OGEC, and whether or not it actually captures all the administrative, legislative, institutional measures that need to be taken by the respondent states in order to accord that full recognition to the OGEC. The respondent in the oral submission indicated that they recognize the culture, language, and religion of the Ogiek. And this is appreciated. And our understanding of this recognition is that it is a recognition that is within the framework of the decision of this court. And therefore, it is inseparably tied to the ancestral land title and ownership of the Ogiek in the Mao forest. The legal team will show that upholding the legal sanctity of the orders of the judgments of the court requires the end of non-implementation of the judgments of the court. This is necessary to enable the respondent state to uphold its legal obligations under the African Charter. And upholding the legal sanctity of the orders of this judgment, the orders of the court, would require the end of the continuing plight of the Ogiek to ensure respect for and protection of their human and people's rights. So we ask once again this court, on the challenge submitted by the applicant, which of these challenges need to be admitted, and because of their consistency with the court protocol, with the African Charter on Human and People's Rights, and the rules of procedure thereto, and which ones actually contest the very judgment of this court and therefore should be set aside. And finally, we ask this court whether, for example, publishing or gazetting, that is one of the requirements of this court, the judgments of this court would cost the respondent state anything. Does it have any financial implications? Does it have any time implications? Does it have any? We haven't been told. That, to our mind, is the list of the orders of the court that can easily be acted upon to show faithful implementation of the orders of the court. Ultimately, the legal team presents the human and people's rights imperative for course correction and the measures this court is invited to adopt to ensure such course correction for achieving the interrelated objectives of ending non-implementation and ending the continuing plight of the Ogiek. With that, I kindly and respectfully request the principal legal counsel of the African Commission to make the rest of the presentation together with the assistant legal counsel. Thank you, Mr. President and Justices of the Court.
Honorable President, Madam Vice President, and members of the court. As earlier introduced, my name is Bahame Tomnyanduga, advocate, lead counsel. I'll be assisted by my learned colleague, Advocate Donna Dare, Executive Director of Pan-African Lawyers Union, who is also part of the team representing the applicant. But I also wish to recognize our colleagues who have supported our work, Mr. Samuel Ndasi and Mr. Kranti, who have been working closely with the victims in this case, as well as Madam Emily Finama, who has done a lot of work in the domestic court cases, which the respondent state referred to. This court, unless I also introduce the people we're talking about, the victims, we'll be talking about papers and the theories. Before you, you have at least 46 representatives of the Ogiek who are here. You can see them in front of you. And on their behalf, you have on our records 4 affidavits which have been sworn to demonstrate the predicament that the community has been going through since the 26th of May 2017, which is exactly around 7 years, short of 7 years since the marriage judgment was rendered. It is, as I stand here today and address the Honorable Court, it is almost 3 years exactly since the reparation judgment and orders were rendered. I would like to introduce to you Mr. Daniel Kobe, who has done a lot of work on behalf of the OGEC, including through raising this matter with the applicant, and eventually the applicant brought this matter here. I'd like to introduce to you Mr. Wilson, whose affidavit, you have it on your record. Particularly when you look at the evictions, recent evictions, where 700 people were removed from Sasimwani, he's one of the victims. I'd like to introduce to you Madam Veronica. She has also sworn an affidavit. And the most recent affidavit, which was sworn on the 6th of May, 2025, which demonstrates what Commissioner Das has explained, that in spite of the orders, there appears to be conditions which impede the implementation of the reparation judgment. So Mr. Stephen Olpotioko Gusilo is here. So when you look at the affidavits, these are the people who have sworn the facts that we are addressing today regarding the problems relating to implementation of this judgment. Honorable President, Madam Vice President, and members of the court, it is incumbent on me to remind the court that the marriage judgment gave 10 orders, and it required the respondent states to take reasonable measures to take appropriate measures within a reasonable time frame to remedy those violations which were found of the various articles which are listed in the marriage judgment. And pursuant to the reparation judgment rendered on the 23rd of June, 2022, there are several other orders, in particular 12 orders, which led to the order requesting an implementation hearing. It has taken 3 years to come to this implementation hearing, and that's why you'll see in our submission that we were even requesting the court to pronounce on the delay on reporting, because the timeline that was set was not met. And since this hearing is historical, it's the first of its kind to determine implementation issues, I think it would be appropriate for the Honorable Court to pronounce itself on what are the legal consequences of non-reporting, albeit that the respondent state has reported, but at least the time which has taken 3 years to report, I think it's incumbent on the Honorable Court to pronounce itself on when a state party to the charter and the protocol do not report timeously as required under Article 30 of the protocol. Article 30 of the protocol is categorical on the obligation of the state to report and to guarantee execution of the court's judgment. So it's on that premise that we are submitting that non-reporting should also be pronounced upon. But secondly, we should also take into consideration the provisions of the charter and the provisions of the protocol, particularly Article 1, which imposes the general obligation of all state parties to give effect to the charter, to the rights pronounced by the charter. So non-implementation at any stage violates that article. Article 27 of the protocol is a very important article. It is actually the basis upon which this implementation hearing is held. Article 27 states that when the Honorable Court pronounce judgment, it will pronounce a remedy which may also have reparation, including compensation. Now, when you look at the orders include pecuniary orders, which goes hand in hand with an order to establish a community development fund to operationalize the committee on the management of the community development fund, and other orders relating to consultation of the OGIEC and effective participation in the reparation process. When you look at those orders and the orders which were rendered on the 23rd of June 2022, compare it with the report. That's when you'll come to the conclusion which you have come to as applicants, as the applicant, that actually the report does not speak to the orders. In other words, you are saying the report has not demonstrated any implementation or compliance by the respondent state. What we expected, and again here we are praying to the Honorable Court, we are requesting the Honorable Court to give direction of what is it that is expected of compliance. What is it that is expected in implementation? In the view of the applicant and counsel, we believe on behalf of the victim that implementation should involve a scorecard, which should be easy to demonstrate that Order 1 has been implemented. And similarly, all the way up to Order 12. Order 12 was the one requiring us to convene the implementation hearing on the report. But when you look at the report, there's nothing to show that that was taken, that was done. Instead, the report of the respondent state, as they have themselves demonstrated, they talk about things like the task force, the interministerial committee, and interagency committee, whose report, first of all, whose constitution or establishment did not involve the effective consultation or participation by the OGIEC, with or by the OGIEC. In other words, it goes direct to violate the orders in the operation orders, which required effective participation and effective consultations. And when you look at the respondent submissions, they give examples of some consultation here and there. And when you look at the total number of the people involved, out of a community of 50,000, you're talking about not more than 400 people, including those which are said to have taken place in public, in some places in Nakuru or the communities, some which took place in the Utalii College. There are certain places which these meetings took. And unfortunately for the respondent states, the participation by various representatives of this community has been seen as a community which is composed of different groups. For the applicant, we consider the recognition of those various representatives as a recognition in a way of people who speak on behalf of the community, and also the fact that the continuing nature of the violations, they keep on recurring. And that's why you have all these numerous organizations which continue to engage the respondent state. In fact, when you look at the affidavits which are referred to earlier, they tell a sad story. They actually speak of desperation. They speak of conditions which have not actually, in spite of all the good presentation by the respondent state and the goodwill. I heard my colleague, my learned counsel, saying that the state is not in conflict with the OGIEC. They are one people. But when you see affidavits of a public agent or a public agents of the state, KFS in particular, or KWS in particular, where they go and evict people from a section of the forest, which in all and practical purposes has been declared in the merit stage, in the merit judgment, as an ancestral home of the Ogiek. So here there is a difference of understanding. When the respondent state, in spite of having the judgment for all these years, 7 years, the merit judgment, they still look at titling, demarcation, allocating parcels of land to individuals. The merit judgment spoke of the Mao forest as the ancestral home and the respondent state to grant a community title. But then the respondent state argues that KFS is going to give user licenses. In other words, when the victims want to go into the Mao, they have to go to the KFS to get permission, and they cannot exercise their indigenous rights. You see, Honorable President, Vice President, and honorable members of the court, it is worthwhile to remember in the merit judgment that it is recognized as a home the Ogiek can exercise their cultural, traditional practices and religious rights. It is similar to any one of our mainstream communities when they go, for instance, to a church or to a mosque. The Mao forest to the Ogiek is their theater, is their hospital, is their source of sustenance as a community. But the way the respondent state is handling the Mao forest, irrespective of the recognition of Mao being a water table, a water source, and all the issues around being beneficial to the Republic of Kenya and Africa as such. But we must also recognize that, and here I want to refer to the reference which was made to the United Nations Framework Convention on Climate Change and the other attendant international conventions, particularly the Paris Accord, the Tokyo Accord, which have been the subject of many international conferences known as the Conference of State Parties, series of them. In September 2022, there was an African Summit on Climate Change. And all these conventions and conferences, they recognize the rights of indigenous people because they are known as conservators. They are known as conservators. In fact, the Mao forest for generations has remained intact because the Ogiek did not destroy them, did not destroy the forest. The forest was destroyed as a result of encroachment by non-Ogiek people. And this is well demonstrated in the merit judgment. So when the orders require consultations on reparation, I think the respondent state should be able to state clearly whether this was done. And for that reason, that's why we're saying all the issues they raised about challenges, about lack of finances, they should have had these issues during the first time when the order was supposed to come before the implementation hearing was supposed to come before the court. And even before coming to the court, they should have had these consultations with the Ogiek in Kenya to be able to have a program of implementation. Now, we have submitted different documents which show as I said earlier, what we consider to be continuing violations, making the implementation very difficult. We don't think, and we submit that the task forces which have been mentioned, the interministerial committee, have never had their report either given to the victims, the Ogiek, or even put up on the website. It is also even stated in the court's report to the African Union that some of these reports are not available. So these are the issues which we expected the respondent state to produce before the court, for the court to be able to determine what exactly is it that has been implemented. So having set out those factual issues and some of the issues around the violations of the protocol because of non-implementation, as well as Article 1 of the Charter, I wanted to take briefly a few minutes to describe what we consider an important, what will be very important pronouncement by the court on the legal consequences of non-implementation, and also speak to the issue which has been raised by the respondents about the multiplicity of institutions, historical, social, and political challenges, as well as what has been seen to an argument which has been made. I didn't hear it being brought out here, but it is in the report where the state has competent institutions, particularly the courts, and they are bound by the 2010 Republic of Kenya Constitution. On the last point, if I may start with it, it is a truism in international law, particularly under Article 27 of the Vienna Convention on the Law of Treaties, that a state cannot invoke its domestic domestic legal system to avoid implementing its obligations. And here I want to emphasize particularly the two articles, Article 27, on the need to grant reparation, because without granting reparation, you are denying the victims their right to a remedy. But secondly, that the judgment of the court arises out of its creation and its jurisdiction under the African Charter, as well as the protocol, which are instruments, international or regional instruments, which the Republic of Kenya has ratified. So this argument about the state not being able to implement because of the different, the domestic jurisdiction or different institutions, it should not really apply in this case. The important thing is for the respondent state to come up with a roadmap which will indicate as from this time onwards, having found the violation of the previous non-implementation of the previous order, but at the end of the hearing, we'll be praying to the court that to make sure as a way forward, first of all, the consultation process is insisted. That consultation process was supposed to take place according to one of the orders to ensure that there is dialogue, what we call a tripartite dialogue, which will involve the state, the victims, who are the Ogiek people, and the third parties who, for a very long time, and the history of how third parties got into the Mao Forest is well detailed in the merit judgment of how they should either be leased those parcels of land which they own, or they pay royalties to the Ogiek community once the community fund is established. And if they cannot agree to that, then because the restitution of the Ogiek is incumbent on the performance of those orders which have been made in the reparation judgment. And where they fail, then the respondent state should come up with a roadmap to show how they will implement in terms of compensating the third parties so that the sanctity of the Mao Forest is kept for the Ogiek as well as for the water resources issue, which have been explained, because the issue of Ogiek management and the conservation of the forest was well established during the merits judgment. Finally, I'll quickly go through what the applicants have submitted on the question of the legal consequences that the Honorable Court has previously referred to jurisprudence relating to the reparation, the right to reparation, the Chazo factory case, which is a well-known authority, which the court has used in its previous decisions. But its own decisions, the Zongo decision, the Ajavo decision, have pronounced the principles around the requirement for implementing reparation, because without that, then it means the right which the courts have granted to the victims becomes hollow. There was a question which was asked by one of the judges, which we also found very interesting. When, for instance, the respondent state says that they find the implementation difficult and they're not sure if it will be implemented to the fullest extent. What we see there is that, and most of the submission actually which were made by the respondent state, is the respondent state is trying to review the decision contrary to Article 28, paragraph 3 of the protocol, which has a specific procedure. In other words, those are the kind of arguments which we should not really give credence to, because they are taking the court back away from what the orders had already made. Finally, I think this is the final. I'll be giving floor to my colleague to address the Honorable Court on the affidavit that we received yesterday. We have gone through it quickly, but we were able to get the gist of it. In fact, some of the things alleged in that affidavit by the respondent state, they prove the non-implementation. But at the same time, there are issues of law, which I think we also need to elucidate on. And I'll be asking my colleague to address the court on that. And finally, to address the issues of the orders that we will pray the court to grant on the way forward from this point onwards. Thank you very much, Honorable President and the members of the court.
May it please, my lords, my ladies. In order to save us time, I adopt fully and associate myself fully with the oral highlights provided by the Honorable Commissioner, Dr. Solomon Ayele Daso, and also with my learned senior Bahame Tom Nyanduga. And we just highlight again our written submissions as well as evidence by the way of affidavits that we have already filed in this matter. I echo Commissioner Daso's appreciation that the most important thing that counsel for the respondent has said is that they have accepted the jurisdiction of this honorable court. They have respected the legitimacy of the decisions that this honorable court made, and that they are committed to implementing them, albeit slowly. I think that's an important admission. I reiterate what learned senior Bahame Nyanduga said. The merits judgment of 26th May 2017 at paragraph 227 gave a number of orders. It listed 8 violations and gave the necessary orders. The reparations judgment of 23rd June 2022 at paragraph 160 gives 12 distinct orders with timelines. My ladies, my lords, it is a simple arithmetic matter from there on what has been implemented or not. It is something that can be put into a table, a matrix, a scorecard. And if we did, and despite the long report, you will see that there's been absolutely no implementation. Even the simple publishing of the judgment in the official gazette and on the websites of the government, of the respondent state, of which there are myriad, even that has not been done. To the contrary, there's been aggravation and multiple layered violations, which we have demonstrated with our 4 affidavits. My ladies, my lords, although we received the compliance report late, and the affidavit even later, that is yesterday afternoon, and the bundle of statutes and authorities were sent only last night to the African Commission at 7 p.m. Banjul time, which was 10 p.m. Arusha time. There are averments that colleagues have made from the bar, which are not even in this affidavit. There are some things that have been said today, and the hazard will bear me right, that are not even in the affidavits. This is adducing evidence from the bar. Then there are also averments that have been made in the written pleadings, which seem to want to relitigate settled decisions of this court. This honorable court has made a very clear decision on merits after listening to all these arguments, constitutional challenges, statutory challenges, practical challenges, and a decision was made on merits. And a decision was made on reparations. So we can't relitigate them. The affidavit, which is the only purported evidence, is glaring in what it fails to show. It claims the existence of a task force, but provides no evidence of it. No names, no gazette notice, who are its members, where are the minutes of its deliberations, where are the records of any deliberations. It claims the existence of an interministerial committee, but similarly does not provide any evidence to it. Where is the gazette notice? Who are its members? Where are the minutes of deliberations? What are the results? The entire affidavit gives no evidence at all of consulting the Ogiek community. If it had, it would have. It would be very clear. In fact, the Ogiek community in their 4 affidavits have said they've not been consulted. And the decision of the Environment and Land Court, which we ourselves cited, but which is also appended to the affidavit, makes it very clear. One of the orders that that decision makes is that the right of the Ogiek people to information was not honored. That is in paragraph 112 of the decision, Tonui versus Kenya Forest Service, which is a decision appended to the affidavit of the respondent, where it says it violated the rights to access information of the Ogiek community by refusing to provide them with the task force reports. The court also, in that decision, that's the Environment and Land Court of Kenya, in that decision says that because this honorable court had given a judgment on reparations, the government should facilitate implementation of that judgment. So that is part of what is in the judgment of that court. In the same decision, the court points out at paragraph, that's paragraph 113, that the establishment of this multi-agency task force in August or September of 2020, which was not gazetted, with no publicized terms of reference, and without involvement of the Ogiek community representatives, yet one of the task force's main objectives, presumably, was implementation of the merits judgment of this court, that whole constitution of the task force was unlawful and lacked any legal backing, and the activities of that task force were a nullity, as it lacked a legal framework to anchor its activities. Coming now to our ultimate prayers, which again, we have listed in our supplementary written submissions. This honorable court had expected the respondent to implement in good faith the decisions that this court made and the orders that it gave. This has not happened. To the contrary, there have been dire consequences to the Ogiek community. There have been further violations. There have been evictions. There have been banning of homes and homesteads. We have people present in this court who are homeless. New violations have occurred. The only line of defense left for this community is this court. There has to be a formal and strict roadmap on how the respondent will implement the decisions of this court, with concrete plans and processes, with clear timelines and milestones on each of the orders of this court. And we plead that there must be a monitoring mechanism for it. We submit that there are various ways to develop this roadmap, especially bearing in mind that violations are continuing. We plead that this honorable court appoints an independent mechanism to go to the respondent state, engage the community, engage the respondent government, engage other parties as appropriate, and develop a roadmap and report back to this court in line with Rule 81 of this court's Rules of Procedure 2020. An independent mechanism can be appointed, for instance, of retired, respected judges from the continent or a panel of experts. So we plead strongly, we plead humbly for an independent mechanism to assist in developing the roadmap for implementation. Even if that is not accepted, in the alternative, we plead that this honorable court order the respondent to develop and submit within 3 months, meaning at the next ordinary session of this honorable court, its own roadmap with very precise timelines. And meanwhile, we plead that this honorable court issue provisional measures. Provisional measures saying that nothing should be done on the land that's already the subject of a decision of this court, until the next session of the court, when the timeline and the roadmap will be presented. We notice a title deed, which we're seeing for the first time, appended to the affidavit that we received yesterday. Obviously, neither the commission nor the Ogio community is able to validate, is able to verify that that title deed exists and that what it says. But we plead that now that it has been put before the court, that the court orders the stay of its implementation until the next session of the court, and that the respondent commits to stay its implementation until we meet again when a proper roadmap with clear timelines and milestones is presented. And we plead that the respondent state provide evidence of consultation, that it will actually have consulted the communities while performing these provisional measures and any other measures that it purports to perform while implementing the decisions of this court. And we further humbly plead to the court to consider that a follow-up compliance hearing be held within the respondent state, where everything is in close proximity of the honorable court and the parties before it. With that, my ladies, my lords, we close our submissions. Thank you.
Honorable President, honorable justices of this court, the legal team presented why, in the views of the applicant, the report on the implementation of the judgments of this court do not demonstrate in clear terms the implementation measures in respect of the 8 orders of the merit judgment and in respect to the 12 orders of the reparations judgment. That the legal team has established that by the admission of the respondent state, that not only that there are orders of the court that were not implemented, which were not specified by the respondent state, but in respect of even those in respect of which the respondent state purported to show implementation, that there is nothing concrete and measurable to establish the existence of meaningful implementation. And it is against this background that the legal team prayed to this court for the court to give an order for the development of a roadmap on the implementation of the 8 merit judgment orders and on the implementation of the 12 reparations judgment orders. A roadmap with clear timelines on each of the orders, with clear milestones, and a roadmap that would be monitored, including through this honorable court. And a roadmap that, in our submission, needs to be developed by an independent mechanism which would work in consultation with the respondent state and the original applicants, the OGIEC. And with that, we would like to yield the floor back to you, Honorable President, Vice President, and Honorable Justices. Thank you very much.
Merci à vous. À présent, je donne la parole aux honorables juges pour...
Now I'm going to give the floor to the honorable judges for any questions to the applicant. Madam Vice President, you have the floor.
Merci, Monsieur le Président.
Thank you, Mr. President.
Moi, j'ai une question à poser au
I have a question for the applicant.
C'est quoi les l'état des lieux des terres aujourd'hui?
What is the status of the lands as of today?
Bien placé pour nous dire
I believe that you are best placed to tell us exactly what the land looks like today. Is it a virgin land? Are there only objects there? Are there ongoing projects on that land? Please tell us exactly the status of this land as of today. Thank you.
Merci beaucoup.
Thank you very much.
Est-ce que les honorables juges ont d'autres questions?
Do the honorable judges have any other questions?
Alors, je ne vois pas de demande de prise de parole.
I don't see any request for the floor.
À présent, nous allons suspendre l'audience.
So at this juncture, we are going to adjourn our sitting to break and come back in an hour. Session adjourned.